An update on the Bryan Kohberger case. He's the man accused of stabbing 4 University of Idaho students to death in their off-campus home last November. We followed each step of the trial, and tonight the defense has filed another motion. Joining us to break this one down, criminal defense attorney Jacqueline Goodman. Jacqueline, thank you so much for joining us again. It's good to see you. We had you on yesterday just to catch us up on, other criminal cases.
Good to see you.
So, Jacqueline, what do you make of this latest alibi claim that Kohberger's defense is trying to present, that he was driving alone and he has a habit of doing that, apparently?
Right. Well, the prosecution asks for, and this is in line with Idaho law, which is different than other jurisdictions, the prosecution is asking for discovery, information about an alibi defense. So that is, what is the defense going to say? Are they going to put a witness on the stand to say affirmatively, I'm his girlfriend and he was with me the whole time and we watched movies together? So the idea is that we don't want trials by ambush. The prosecution has a right to have notice of what witnesses are going to say with respect to an alibi in Idaho. And so they ask for that. And we saw last month that the defense filed a motion to sort of hedge their bet a little bit and say, well, we don't exactly have witnesses that we're going to tell you about, but we think that by cross-examination of your experts and maybe ours, and by cross-examination of your witnesses, prosecutor, we're going to establish that he wasn't at the residence where the killing occurred. And so the corollary to that is that he was in another place. That's sort of an alibi. So they were kind of, filing something that would get over their requirement in Idaho law for their notice to the prosecutor, and yet kind of keep their options open. Prosecutor responded to that recently by saying, no, we want a motion to compel. Who are the witnesses on whom you are going to rely so that we know that we can check out that actual alibi? And then the defense now today is saying, look, here's what we're going to do. We've got this theory that he is driving around on the night of the 12th and on the night of the 13th, as he is wont to do. And so that information may come to light in the trial, and again, through experts and through cross-examination of the prosecution's witness. So we have a little bit more of an alibi, and it's not exactly an alibi. It's that they're saying he wasn't there where the murders occurred. He was driving around.
So, Jacqueline, as you mentioned, they have instances of 2 particular nights when they're trying to prove this defense claim. Now, do they have to find a lengthier pattern to get this to work?
In a perfect world, yes, right? They would. But in the world in which we live and in which the Kohberger defense team lives, they're going to use everything at their disposal. So what they're trying to do is allow for the possibility of new information to come out that doesn't preclude them from making these arguments. And so I think it's probably a very sound strategy, to be honest with you. I think everybody wants to hear, well, if you weren't there, tell us the truth about where you were. And that really is something that we refer to as burden shifting. It isn't the defense's burden to prove he wasn't there or that he didn't commit the crime. It's the prosecution's burden to prove that there's no other reasonable explanation for the evidence the jury is going to get, but that Mr. Kohberger is guilty. So they're allowing themselves this sort of halfway, and also the possibility that they may talk about an alibi. They may be alleging that they're putting up the possibility that he was somewhere other than the house where the murders occurred.
So, Jacqueline, I actually have that entire motion right here. We have been dissecting it in the newsroom as soon as we got it. The alibi provided by his defense team seems to be aimed at cell phone pings linking Kohberger to the area near the victims' homes. But what about any other evidence, for example, the knife sheath or the DNA, etc.? Do they not need to think about all those factors in this case and just provide whatever information they think is important?
Well, again, it's sort of burden shifting, right? We're not really requiring a defendant to tell everybody how it is that this evidence comes together. But interesting, you bring up the knife sheath. So we've got some DNA that matches Mr. Kohberger on this sheath, this carrier of a knife, but we don't have a knife. Prosecution doesn't have the knife. And again, very importantly, there's no DNA in his car. There's no DNA in his home. There's no DNA really anywhere else linked to Mr. Kohberger of any of the victims. And the other thing that is interesting in these papers that we see for the first time is that the prosecution hasn't let on what it is they have used to determine that there was this Elantra, the kind of car that Mr. Kohberger drove. They're alleging that he used that car that night, but they're not telling us why they think the Elantra had anything to do with these murders. And so one of the objections that the defense makes is they're saying, hey, look, this is your fault, Mr. Prosecutor. You could have had a preliminary hearing where we would all see in the light of day all of this evidence and we can argue it and talk about it. And instead, you decided to go sort of behind closed doors at this grand jury where defense lawyers are not allowed to be and get an indictment from a grand jury in secret. So they decided to do that. They decided to hold their cards close to the vest. And so that the defense is saying is part of the problem with the defense today not having all of the answers.
So Jacqueline, Kohberger is still standing silent when it comes to this case. Is there a scenario where he would have to testify about his provided alibi?
You know, a defendant has the absolute right to remain silent and the absolute right to testify if he wants to. And so typically what will happen is that if there's no other possibility, if the thing looks pretty hopeless, then we put our clients on the stand. Otherwise, you know, it's a question of whether the prosecution has proven their case. And so it is totally reasonable and quite frankly, what I would expect for Mr. Kohberger not to take the stand and to rely on the state of the evidence. There's a lot missing in the prosecution's evidence against him. I mean, that's not to say that there isn't a lot of evidence against him, but there's a lot of questions, and questions really amount to reasonable doubt. You know, unanswered questions for the jury, scratching their head, trying to figure out how you can put this together with that. That's reasonable doubt. And so that's every bit Mr. Kohberger's right to rely on the failings of the prosecution's case against him.
So this latest filing also mentions a significant amount of discovery. And how is that going to factor into the trial? Do you think it's going to start on time, or could it be delayed?
Might be delayed. It's a very, very serious case. And if the parties need more time to exchange information, to digest that information, and to see how that information is significant to the defense and or the prosecution, a judge is going to rely on their good faith, their good work, and give them time if they need it. So if they can show good cause, meaning that there's, despite their best efforts and their due diligence, they need more time to prepare, then a judge is going to give it to them, and particularly in a death penalty case. So looks like, you know, we have a trial that's set to start October 2nd, but I think that's more aspirational than it is real. We'll see what happens.
Jacqueline, finally, do you think that all the pretrial motions will get addressed at the August 18th hearing?
All of them so far, yes. The pretrial motions are really ways that we set up the rules for engagement in this trial. So as things change and as things develop, there will be more need for additional motions. There could be additional developments that happen, and so we would address those as time goes on. But for now, this is all we know about, and they're likely to be addressed on that date.
Jacqueline Goodman, always good to have you here on Live Now from Fox, helping us break down these very complicated cases. Yesterday was another death penalty case, and this one, again, although now we get to kind of dissect it before a sentencing is set. So we will welcome you back, of course, anytime as we continue to follow this going forward.
My pleasure. Thank you.